Good afternoon, members. Today is Monday. This is the Tennessee Athletic Commission's regularly scheduled meeting, Monday, June 13th. My name's Roxana Gamusio. I am the executive director with this program. I know we will miss Glenn Kopchak immensely, and as he mentioned, I want to share that great opportunity for him. He's now executive director with the Architects and Engineers and some of our other property boards, and so I know he also would have loved to have come by and said hello to you all, but he's with a different program and excited with that change. So I appreciate everyone being here on time for the meeting. We will get started first and foremost by doing roll call vote to assure we've got quorum. Ben Grove is not here with us today. Matt Reddish.
Present.
Dr. Christy Halbert. Patrick Wren is also not here with us today. Dan McGrew.
Present.
Thank you. We have quorum. This meeting was noticed on the board's website for the June 13th, 2022 meeting. It was noticed as far as the date, time, and location on the website since June 16th of 2020. Additionally, this month's agenda has been posted since June the 7th. As far as the agenda goes, it was emailed to all of our members, and it's also on your iPads. If you've had a chance to review the agenda, I would need a motion to accept it as is.
I second.
Thank you. We have a motion by Dr. Halbert and a second by Mr. McGrew. All those in favor?
Aye.
Thank you. Passes. Next, the September minutes were also sent via email to all of our members. If there are any changes, I welcome those to update our records. Otherwise, we would also need a motion and a second.
Motion to accept.
I second.
We have a motion by Matt Reddish and a second by Dan McCrew.
Patrick Wren
is now joining.
Mr. Rand, I know you're on the meeting with us. Thank you for joining us.
Yes, ma'am. Thank you for having me today.
Absolutely. We are thrilled. Wish you all the best today. We have quorum here in the building, so we will not be doing roll call vote for our motions, but please feel free to unmute yourself and ask any questions as we go through.
That sounds great. Thank you very much.
Thank you.
And I hope all of you fine folks on the board there are doing well. And I appreciate your kind thoughts about my daughter.
Absolutely, sir. We are here always. If you need anything at all we can help with, just thrilled to have you participating with us. We had a motion by Matt Reddish and a second by Dan McGrew for the September minutes. Is everyone in agreement? Motion unanimous. Thank you. I will go ahead then, and staying with our agenda, we will pass this over to our attorney for the program, Pamela Spicer, and start the rulemaking hearing. And members, the documents for the rulemaking hearing were also sent via email. They start on page 5 of your iPads.
Good afternoon, everyone. This is the rulemaking hearing for the Tennessee Athletic Commission. My name is Pam Spicer. I'm Chief Counsel for the Department of Commerce and Insurance Regulatory Boards. Can I have everyone introduce themselves for the record?
Matthew Reddish.
Dan McGrew.
Christy Halbert.
Patrick Wren.
And Roxana, if you don't mind introducing yourself.
Oh, I'm sorry. I'm paying attention to them. Roxana Gamusio.
Thank you.
Thank you.
I will proceed with the rulemaking hearing now. As a point of reference, you all actually first discussed these rules back in September, if not before September of 2021. Then, due to statutory changes in the law that went into effect in October, additional amendments were made to the rules, and now these rules are before you at a rulemaking hearing. Today is Monday, June 13th, 2022. The rulemaking hearing is taking place in the Davy Crockett Tower, Room 1B, pursuant to Tennessee Code Annotated 45204. This meeting is also being live streamed via electronic means, via Teams, is my understanding. Anyone wishing to make comments can put their comment in the chat box, and we will get to those at the appropriate time. Also, this rulemaking hearing was noticed properly, and anyone wishing to participate in public to make comments is able to do that by signing up. And I have also provided a copy of the red line of the rules for the public if they intend to make comments. These proposed rules are before you today because of certain statutory changes in the law, as I mentioned earlier, that went into effect October 1, 2021. Also, these rules are amending our rules to become in line with the unified rules of the MMA and the ABC boxing rules. I will read into the record later the summary of the rules that you'll be considering. There's several pieces of information that I need to go through today. We will do roll call votes when appropriate, but there's first some information I need to read into the record. A rule is defined as an agency statement of general applicability that implements or prescribes law or policy or describes the procedures or practice requirements of the agencies. These rules are filed with the Secretary of State, the public is given notice, and a rulemaking hearing is held. Upon conclusion of today's hearing, the rules will be forwarded to the Attorney General's office for review. They will then be filed with the Secretary of State and will eventually go before the Government Operations Committee of the General Assembly. The rules must be stayed with the Secretary of State's office for 90 days, and at the end of the 90 days, they will become effective. Is there anyone here from the public that wishes to speak on the rules? As I stated, you must sign in on the sign-in sheet that's been provided or provide your information in the chat box. Notice of this rulemaking hearing was published on the Tennessee Secretary of State's website on March 21st, 2022, and an e-notify was published by our office on April 4th and April 19th of this year. I will now take a moment to summarize the rules which you have on your iPads today. The first change to these rules has to do with licensing. 0145-01-.03, and that's due to a statutory change in the law that increases the period of time for combatants to have medical with our office from 30 to 90. Next change. Combatants, I'm sorry. And it discusses failing to appear for a weigh-in for any pre-fight meetings, and if they fail to appear, they will be subject to discipline. Related to the professional boxing section, .02, which is 0145-02, we are increasing the number of seconds allowed from 3 to 5. In Rule 0145-02-10, we are removing the standing 8 count. As it relates to scoring in .12, we are again removing the language regarding the standing 8 count and renumbering the paragraphs. Moving forward, same section, .13, we are also adding specific pronoun language you'll see throughout the rules related to he and she, her, him, things of that nature. In addition, we are removing the 3 knockdown rule. That was number 7. And renumbering accordingly, adding in no standing 8 count, no 3 knockdown rule, and a boxer who has been knocked down cannot be saved by the bell. We are also adding that a fighter that is hit with an accidental low blow must continue after a reasonable amount of time, but no more than 5 minutes, or he or she will lose the fight. Related to kickboxing and mixed martial arts, which can be found in 0145-03. We are adding language to the referee section that talks about a referee has the reason to believe a foul when he or she did not see it have been committed. He or she may poll the judges to determine if the foul has been committed. Additionally, related to results of contests, we have added and removed some language related to submissions regarding tap outs, verbal tap outs, and added technical submissions. Related to technical knockouts, we have removed the referee stopping the contest and added A and B directing the referee's stoppage due to strikes, lacerations, corner stoppage, did not answer the bell, TKO due to a medical stoppage, which is lacerations, doctor stoppage, or loss of control of bodily function. We've also added in the referee stoppage due to the combatant not intentionally being able to defend himself due to strikes. We've added in some information about scorecards that was not previously there. The A through D was there as far as unanimous decision, split decision, majority decision, and draw. We've just added in an explanation of what that means. Same continuing on 6, 7, 8, and 9 of that section. Moving to weight classifications, we have added in language to the weight classifications section that says if a combatant misses the contracted weight and the two competitors are in different weight classes, the heavier component shall not exceed 5 pounds of the lower weight of the fighter. The last amendment to the rule packet has to do with female combatants and what they are allowed to wear. They shall wear a short sleeve above the elbow or sleeveless form-fitting rash guard or sports bra. No loose-fitting tops or breast protectors shall be allowed. That concludes the summary of the rules as presented today. I will need a roll call vote to adopt these rules, and then there will be some additional information that we will need to go through.
Thank you, Pam. By roll call vote to adopt these, Matt Reddish,
Aye.
Christy Halbert, Dan McGrew,
Aye.
Patrick Wren.
Aye.
Thank you, Pam. It's unanimous.
Thank you. Also, to clarify, for purposes of the rulemaking hearing, I see no one has signed up to make any public comment today. I have not received any comment. The executive director has not received any comments. And do we have any comments in the chat box? There being no comments in the chat box, I will move to the next section of the rulemaking hearing. Pursuant to Tennessee Code annotated section 45222, we will need a roll call vote to adopt the regulatory flexibility addendum. I will provide a summary for all of those participating via electronic means and for the board members. Pursuant to TCA 401 through 404, this rulemaking process, as part of that, we must consider a review of the regulatory flexibility addendum and how the rule may affect small businesses. We do not intend to state that any effect will be on the local businesses or small businesses. The Athletic Commission has approximately 226 licensed combatants, 103 ring officials, 435 seconds, and about 11 promoters and managers. We, again, do not anticipate any problem with small business. We do not project any reporting, record keeping, or other administrative costs related to compliance with these additional rules. We also find that there is no less burdensome alternative to these rulemaking hearing rules. These rules will eliminate conflict between the American Boxing Association and Commission for Competitive Sports and the Unified Rules of Boxing and Mixed Martial Arts. There is no less burdensome way to achieve the goals for Tennessee and to comply with adopting said rules to make us in compliance with the MMA and boxing. In addition, the change related to the 90 days is a statutory requirement. I will need a motion and roll call vote to adopt the regulatory flexibility addendum.
I make a motion to adopt the regulatory flexibility amendment.
Thank you. By roll call vote to adopt the flexibility amendment as stated, Matt Reddish,
Aye.
Christy Halbert, Dan McGrew,
Aye.
Patrick Wren.
Aye.
It is adopted.
Also, I will need a roll call vote to adopt the impact on local government. There is no projected impact on local government as required by statute. I'm required to tell you all that, and now I will need a roll call vote for the impact on local government, which is none.
Thank you. Matt Reddish, Christy Halbert, Dan McGrew,
Aye.
Patrick Wren.
Aye.
It is adopted.
Included in your packet should be the required information for the Joint Government Operations Committee. This is the last summary that I will need to give and ask you to adopt by roll call vote. Again, as I stated, these rules are necessary to become compliant with the MMA and boxing rules. Also, they are due to statutory changes in the Tennessee law. The ABC and Mixed Martial Arts set out national standards, which we become compliant with and try to align in every way with the ABC and MMA. The rulemaking hearing will affect licensees for both MMA and boxing. We'll clarify any ambiguity that exists between the MMA rules and the ABC rules related to our rules. There is no known Attorney General opinion that would be in conflict with these rules. There's no known expenditure that would cause any issues with these rules. In fact, we hope that becoming more compliant with the MMA and boxing, that we will increase the number of events here in Tennessee. And the rules are presented at the Joint Government Operations Committee. Members of the department will attend that hearing on behalf of the Commission. I will now need a roll call vote to adopt the Government Operations Committee.
Roll call vote, Matt Reddish,
Aye.
Christy Halbert, Dan McGrew,
Aye.
and Patrick Wren.
Aye.
All in agreement.
As I stated, these rules will now go forth. They will be submitted to the Attorney General's office for review. They will eventually be published the Secretary of State again, and we will go before Government Ops. And then after that, these rules will become effective in approximately 90 days after we appear before the Government Operations Committee. That concludes the rulemaking hearing. There being no additional questions, we will move to the next item on the agenda.
Thank you, Pam. Thank you, Commission members. Next on our agenda is an application review. This item is on your iPad starting on page 21. It was not emailed to everyone because it does have some confidential information. This is an application presented for a promoter license from Mr. Kevin Kenmore. The application revealed personal information as well as working relationship with Tracy Crutcher Kenmore. That is his wife. That particular license was suspended in September of 2021, and therefore it is before the Commission to review and discuss if this is something they would like the office to deny or treat differently, and Ms. Spicer might also be able to answer any questions you have.
If you would, could you refresh our memories as far as what the license was suspended for?
Thank you.
Yes, I'm happy to do that. This suspension was by agreement with Tracy Crutcher Kenmore. It was suspended effective September 20th, 2021. The order that she agreed to sign specifically states that we received information from Request to Test that blood work was submitted through LabCorp for several combatants, and that was determined to be fraudulent. Her license is still suspended. This matter is still pending because we have not had a final hearing on it. But none of the information that she submitted related to the blood work for her combatants could be verified.
Thank you. I do remember that now. Also, was there a fine attached to that?
No, this was a summary suspension, so we have not had a hearing. Normally, when we proceed on a summary suspension, that's related to the public health and safety, and a civil penalty is not attached to a summary suspension normally.
So, as I understand it, she's reapplying now for a license?
She is not applying. Her husband is applying. They share the same home address and same business address.
So I guess we can discuss whether or not, well,
I could give you some additional information that you can consider. The name of Kevin Kenmore's business is 4611 Boxing Promotions. He applied for an application, I believe it was in February of this year. According to his website, he states that he is a coach, manager, and CEO of 4611 Boxing Promotions. Furthermore, on his website, he specifically lists and continues as of today to list Tracy Kenmore as a promoter for his. This individual is also his wife.
Yes, it is on that application that you're looking at. That's correct.
Yes, both the applicant's address, Kevin Kenmore, and Tracy Kenmore's address is 4611 Paul Trail, Chattanooga, Tennessee, 37146.
Now, when again was is the hearing scheduled for her?
The hearing is not scheduled for her yet, so the matter is still pending before this board.
We know if he had any dealings with that particular incident that caused her to get her license suspended. What his role, did he have any type of role that you know of in that?
We do not know specifically what his role was or not. There may be proof that would come out at the hearing in this matter, but Ms. Cunningham agreed to the summary suspension, so we haven't had a hearing yet to, I guess, flush out exactly what he would or would not have known. However, they work at the same facility, and they obviously have a relationship, so it would be within this board's discretion to consider those factors when considering his application. Also, he continues to hold his wife out as a promoter with his company, and her license is currently suspended.
Was he notified that we would be discussing his application today?
Yes, he was notified by the program via email that we would be considering this at today's meeting.
I assume he's not in attendance.
That's correct. We did not hear back from him, which surprised us a little bit, so, but he's not.
Well, in my opinion, considering the closeness that they were probably working together on these events, this looks like maybe kind of a end around type of way of bypassing the hearing or the suspension. And until that particular hearing takes place, I don't think that we should consider this particular application, in my opinion. Anyone else?
If you all are inclined, if you have additional questions, that's also fine. Or if you're inclined to deny the application of Mr. Kennemore, I believe we would need a motion on that.
You have like a time frame where we have to approve or deny?
I don't know of a time frame at all. Of course, he applied in February of this year, and it's before you today. As Roxana mentioned, we have not heard from him or Ms. Kennemore since we notified them that this would be heard today. I don't know that there is a policy necessarily. It could result in another complaint if this commission directed the administration to lodge another complaint against Ms. Kennemore. And then we would flush that out through the complaint process. It would be, for instance, no different than anyone else advertising that they were a licensed promoter anywhere. We would likely open up an administrative complaint. In addition, 68-115-204 does specifically state that all combatants for professional contests, promoters, managers, matchmakers, seconds, ringside physicians, and other ringside officials shall be licensed by the commission. And Mr. Kennemore, on his website, identifies as a manager.
I would motion that we move this to the next hearing. We ask him to appear and explain, because we have no concerns about his wife engaging in unlicensed activity. Just some general questions I'd have for him. I don't think the fact that his wife had her license suspended will automatically disqualify him, in my opinion. But I think he should come down here and answer some of the questions and concerns we have. So I just motion that we move it to next meeting, and if he doesn't appear next meeting, then we'll address it again.
We have a motion by Matt Reddish and a second by Christy Halbert to request in writing that Mr. Kenmore appear for the next meeting, give him the meeting date and time, and request you would like him to appear in person or virtual. Does it matter?
Do I have any thoughts on in person or allowing virtual?
I think either one would suffice.
I agree.
We have a motion and a second. All those in agreement say aye.
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 Any opposed? Okay. That letter will be sent to him by the end of the week with that information. Thank you very much. Thank you, Pam. Commission members, next on our agenda is a review. This is a quick review. I know that at each meeting we've talked about the budget. These final numbers are as of April 2022. And of course, it does show us, not being self-sufficient at this moment. I believe the total brings us to 30,812 in the red. We have made huge strides with the inspections team, and I know that you all know the work that they do on all of our events. They have brought in additional part-time folks so that the traveling is kept down, because that can add up very quickly. So we've made all those changes. The assistant commissioner is very aware of the budget situations, but at this point we're doing the best we can to juggle it all. And of course we haven't had a big event in a while, but with these rule changes and other events coming in, hopefully we'll have some of those change around. The medium to bigger events are the ones that help us, obviously. If you have any questions, I welcome those. Otherwise, this is just an informational update for us. Yes. We do not at this moment. We have heard through the grapevine that, something was coming, but nothing's been filed just yet. Nothing, no event permits, that kind of thing. So we'll keep recommending things. One of the efforts that Glenn did for a while was reaching out even to the Department of Tourism through the tourism site. So we're going to try some of that as well, just to promote some of those things and see what we can get.
Are most of our expenses are we still using like department people to go and regulate the events, or full-time employees?
They're full-time, but we have more part-time now than full-time. So we save there on the benefits. The travel is what gets us, and that's the advantage of using part-time folks. Then they don't have to travel as far, and they're just there for the day. So that helps a lot. But
Remember they made a push to have part-time inspectors?
yes, and we've got, I think, 10 or 12 right now trained and going out. So that push has made a difference. We were turning in kind of a profit and loss every day with each event, and we did that for probably about 9 months to conclude that those smaller events are just really difficult to even break even. So the size definitely makes a difference for us. Next, you have just an item we have to do each year. This is our first meeting for the year, so we do need an election of officers. Currently, we have Chair Dan McGrew, and as Vice Chair Patrick Wren. I welcome any conversations. We would need a motion and a second for each one of these, or to keep the same. It is completely up to the commission how you wish to proceed for all of the rest of 2022.
Can you have the board member speak into their microphone, please?
Oh, yes.
Oh, sorry, I thought I did.
You're good now.
Just wanted to thank those members for their service in those roles, and make a motion that they stay on.
I'll second.
Thank you, Christy. We have a motion by Christy Halbert and a second by Matt Reddish to First of all, thanking the members that have served as chair and vice chair and to stay on for next year. And that would mean Dan McCrew staying as chair for the Tennessee Athletic Commission and as vice chair, Patrick Wren. Are all those in agreement? Say aye.
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 Do we have any opposition? Hearing none. Thank you very much, and I too thank you for your service, because I know I can always rely on everyone on the commission, but it is good to have that individuals do it one more time. They know what they're doing. So next we're on to the legal report. This too is on your iPads, and it starts on page 25, and I'll turn it back to Ms. Spicer.
Afternoon. I'll let you all review the report. There are 12 total complaints to consider. I do want to note on number 1 that this participant is now licensed with license number 5584, licensed April 18th, 2022.
Need a motion to accept the recommendation? We're going to go through each one in motion.
We do not need to go through each one. I was going to give you all an opportunity to review and then note any changes since I sent the report. And specifically on number 1, I noticed that it still said that that individual was unlicensed, which that person is no longer unlicensed. Hence my recommendation of closure. I do not have any other changes to the report, but I'm happy to discuss any that you all want to discuss. We'll also notice that 10, 11, and 12 are represents. And those are all due to me being unable to locate the individual.
That was 10, 11, and 12?
Yes, those are 10, 11, and 12.
Talk more about number 2, not supplying sufficient medical liability. Is that something that's given at the time we issue the event permit?
Yes.
And was the permit given?
Yes.
Yes, it did.
It did, yeah.
Oh my God.
On number 7, what's the minimum that we usually get from our events? Isn't there a minimum
For the gate fee,
minimum gate fee that we
the
accept?
500.
The receipt's been requested and they're just refusing to provide them.
Yes, it is my understanding they have been requested.
I think I'd motion to increase that $500 penalty to $1,000 to be reduced to $200 if the receipts are given. I mean, $500 is what is the minimum he should have paid. So he's basically breaking even by not complying with our request to provide them. So that'd be my motion.
on number 7 is what you're speaking of, correct?
Correct.
Was that particular show, was that the one held in Nashville? You recall?
I don't recall specifically. I would have to look back at the complaint.
In a case like this, is the promoter permitted to hold an event? Has this ever occurred in the past? And can you give us some idea of how we typically proceed?
We follow up a lot. So it has never happened to this level that the event has already gone through and we can't get any kind of receipts. But it does take, they're not the exception in us needing to follow up to get the $500 or the receipts to determine if it needs to be more.
I believe on our last meeting, we imposed some penalties on at least one individual that I remember. I don't see that, I can't recognize that one on this list.
It wouldn't necessarily be, if it was on a prior legal report, it would not appear on this legal report. The only represents are related to complaints where there's an issue that comes up after the complaint is presented to you all, and I make a recommendation. You all accept the recommendation, and then something is discovered later, which would bring that matter back before.
Is now exiting.
Patrick Wren.
Is now exiting.
I did.
Mr. Reddish's motion was related to number 7. If you all have had an,
Can I add to his motion?
for number 7?
Yes.
Yes.
That a event permit not be issued for a promoter who has ongoing business with the unresolved, business with the commission.
If I'm understanding on this one, that this promoter not be issued a future event permit because this is pending until it's resolved.
Yes.
Perfect. And is the motion to increase the civil penalty to $1,000 with the option to give us the receipts and timely pay and then drop to $500 if that's the correct amount?
It was my understanding the motion was 1,000 reduced to 200. If the report is received and until the penalty is paid, that another permit not be issued.
I believe that's my understanding of my motion as well, as amended.
Now, as I understand it and as I read it here, it was we were due to receive that within 30 days, correct? And
Correct.
that time has passed. All right, so what the motion says is we will give him another 30 days and $500 civil penalty reduced to $200 if it's not received within 30 days. Is that correct?
That was
And
the recommendation.
That was the recommendation, which has now been increased to 1,000.
1,000 instead of-
Reduced to 200 if the receipt report is received within 30 days. In addition, we would not issue another permit to this promoter until the civil penalty is satisfied.
But he will get an additional 30 days.
Yes, because he would have to receive what we refer to as a consent order,
Right.
which is a settlement document. He or she with the information that he or she needs to pay the $1,000 or provide us with the report, and it will be reduced to $200.
So the motion has been made. Has it been seconded?
No.
Were you seconding it, your addition, or not?
We have a motion by Matthew Reddish and a second by Christy Halbert. And again, it is to change the recommendation for number 7, which is complaint number 2022-010421, related to the promoter, a $1,000 civil penalty reduced to $200 if the receipt report is received by our office within 30 days, and until that is satisfied, another permit will not be issued for this promoter. In addition to the changes on number 7, I would also need a motion and a second to adopt the entire legal report with that one change on number 7. Oh,
Numbers 8 and 9 both have to do with illegal events, correct? Events taking place without event permits.
correct. On number 8, we do not have any additional information other than this was an unsanctioned, unlicensed event. On number 9, the respondent provided a response disputing that it was an unlicensed event. It was a response that provided information that it was a personal training fight camp, not a boxing event. By specifics, I don't know exactly what specifics there would be, but there wasn't anything additional provided. You know, there weren't photographs, in other words, but they did provide information about the fee that was charged for these individuals to do the personal training fight camp. Well, first and foremost, sanctioned office, but it would probably depend on the circumstances. I hate to say that, but obviously the commission is looking at whether to license an event or not versus really speaking, not necessarily on a personal level, but, if you go to one of these boxing facilities, not everything they do is a boxing event. They just may have people working out in there. They may have, I guess, to answer your question, we would be taking this individual or company at their word that this was not a boxing event. And they do not have any history with the department that would cause us to believe otherwise.
Well, do you know if there was a fee charged for the public?
It is my understanding the only fee charged was for the individuals entering the personal training fight camp
Oh,
itself.
that particular fight camp, Do they have any type of insurance, as you know of? I mean, was it insured by any particular organization?
No, we do not have any information about whether it was insured or not.
I think in general, a big part of what we look for is if the combatants are being paid, which would make it professional. I know, for example, that we don't regulate amateur events.
I was not provided any information that this was an event where there were judges involved and that there was no, as Mr. Reddish was stating, there was no money paid to the people that paid to enter the fight camp.
I'm sorry, can I? There you
But-
go. Now I hear you.
Given that numbers 8 and 9 are so similar, and we're asking for authorization to authorize a formal hearing for number 8, I would move that we do the same for number 9, authorize a formal hearing.
With a formal hearing, normally there is a recommendation for settlement. On number 8, it's authorization for formal hearing and authorized settlement by consent order with $1,000 civil penalty. Are you making a similar recommendation for number 9?
Yes.
And what this may do, for the benefit of the commission as well, if that motion is seconded, is when I send the consent order, sometimes respondents, I'm speaking for other boards now that I've been involved with, sometimes when you send a consent order to a respondent, that may prompt them to provide us with additional information where the commission might feel more comfortable that this was not a boxing event. In the end, depending on my review of that information, I may come back before the board at the next meeting with a represent to ask you all to consider this additional information.
How did this complaint come to us?
That I don't know unless I look up the complaint. I can ask my paralegal to make sure whether it was an administrative complaint. He's here, so. I do know from the unredacted version that there are 2 different companies.
Okay, and were they both, are numbers 8 and 9 both boxing specific?
9 was, let me find out about 8. If you'll give us just a minute, we'll find out. For number 8, it does not say whether it was a boxing event or not. In the complaint, it was opened as an administrative complaint.
Oh, there we go. In the case of complaints regarding illegal boxing, does the commission ever solicit information from USA Boxing to assist in investigation?
I think at times the persons working may look up information, and then we can look up information when a complaint, depending on what information is available. I would have to rely on the program for that information.
Were you able to find how complaint number 9 came in?
Complaint number 9 was from the outside, not administrative complaint.
So as of right now, we have 2 different motions. One has been seconded. Is that correct? Number 7.
Number 7 is number 9 has a motion from Christie to duplicate the civil penalty and order just like number 8.
So now 8 and 9 are connected. The motion was for 8 and 9.
Correct. We need a second on that.
The number 8 has not been changed. It's right. It's authorized formal hearing and $1,000 civil penalty. And I do want to make clear that they're not related complaints.
Correct.
We're talking about 2 different companies.
So the other motion that has been made is for number 9 also, but it has not been seconded as of yet.
And the response to number 9 from the complainant, was it just like one sentence saying that it was a fight camp? Or, I mean, I assume you reviewed it.
The information provided from the respondent was, as I recall, a couple of pages with specific descriptions about what went on during the fight camp, and a distinction that it was not a boxing event. Of course, the event has already occurred, which makes it difficult to investigate because the event's already occurred. And that's why I was pointing out that there's been no complaint history for this particular entity. Obviously, they're not licensed, but we've had no other information that they've committed any other unlicensed activity.
Do we know if USA Boxing sanctioned them for an illegal amateur boxing event?
We do not know.
Number 9, I'm just having a little bit of an issue because if we don't have any evidence that these people were paid and it was a professional event, I don't exactly like sending no consent order asking them to pay $1,000 if we don't have more information. I think possibly we could leave it open and have Pam reach out to them for clarification, possibly if we have some follow-up questions, or maybe a letter of warning, depending on where you're personally at. I don't really like authorizing it to go to a hearing if we don't think we have enough facts to probably enforce a letter for a civil penalty. It's my personal feeling.
I'm
On
comfortable
the motion.
withdrawing the motion if we can investigate further. And I guess my concern is we do not regulate amateur boxing, but we do require amateur boxing events to go through their respective amateur organization if they are holding amateur events. So if boxing events, for example, or MMA are taking place, they should be regulated either through our commission or through their respective amateur commission. And at this point, we're not sure what happened on the amateur side. So I'm comfortable withdrawing the motion if we investigate further and follow the recommendation of the other commissioner.
I can reach out to the respondent, see what information I can find out, and then I can also sanctioning that. I guess my concern would be there may not be any because entity fight camp that wasn't subject to any regulation, but I'm happy to see what I can find out, and then we'll bring it back to the commission at the next meeting, because I could get some clarification from the entity, asking maybe for more confirmation whether there was insurance, which may lead itself to an event, because if you had insurance for a boxing event, not a fight camp. Now, they may have insurance related to their entity, which would be separate, but I'm happy to ask some additional questions of the respondent and then also see what I find out and bring it back to the commission at the next meeting.
I'd appreciate that. I would just really hate to send a letter telling them they owe us $1,000 if they really were just holding a fight camp. I think that would not appear great on our behalf.
So on number 9, we're removing it from the report, and the only additional change then is we're back to 7, which has already been changed. So unless there's further questions or comments about the legal report, I still would need a motion and a second to adopt the legal report with the changes which have already been discussed on number 7, and then we are removing number 9.
A motion to accept the legal report with number 7 modified and number 9 removed.
I second.
I have a motion to proceed as Matt Reddish described, and a second by Dan McGrew. All those in favor, say aye.
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 Any opposed?
Aye.
Thank you, Patrick. Thank you. That concludes the legal report with its revisions. The last item that we have under new business is on your iPads. It's the very last page, and these are our 2023 meeting dates. We've stayed consistent with this year's and previous years' Mondays at 2 in the afternoon. We have March 13th, June 12th, September 11th, and December 11th. And what I will do is email these dates to all of our commission members to make sure you have them for your calendars for next year. But I would need a motion if those dates are approved to reserve the rooms and populate our website.
I'll make that motion.
Second.
Thank you. We have a Albert and a second by Matt Reddish. All those in favor say aye.
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 Any opposed say no. Thank you. The motion carries unanimously. And members, I have nothing else. I want to make sure that you have an opportunity if you have any questions or anything else before we conclude.
I have one. Since our last meeting, which was March 13th, have there been any new promoters that have been licensed?
Katie, I hate to put you on the spot. Can you think of any since March? The application you reviewed today is from February 28th, and of course it had been delayed, not really denied or approved, but that would have been one. But it's my understanding that we've stayed pretty consistent. Our numbers haven't fluctuated with.
Okay, because I do know.
Katie?
Masvidal, from what I don't know if that's been since for a
What was the name again?
Jorge Masvidal. He did apply for a promoter's license, but there's yet to be an event permit put in or anything on it thus far.
Okay.
I don't know if that's been since March though, but it's been this year.
Right. Is he out of what is he out of
UFC fighter.
he's a UFC.
Yeah.
Yeah, this would be UFC.
Okay.
They were looking at bare knuckle too, but we haven't really discussed all that. We haven't.
Well, can you tell me if there was a new promoter's license granted to an individual in Harrogate, Tennessee?
I honestly wouldn't know off the top of my
can't.
head.
I can't imagine, Kate. But what we can do after the meeting, if I'll make sure to get that information from you, we'll look them up and we can even send you a list of the approved promoters. That's public information. We're actually asked pretty often to submit via our public records request that's online.
Okay.
List of anyone that's promoter, events coming up, fighters, so that people can look. So I'll be happy to get that to the commission.
All right. Thank
Does
you.
that help? Absolutely. Members, if there's nothing else, we would need a motion to adjourn.
I think I have one other question.
Yes, sir.
Our individual who we summary suspended, who's listed as a promoter on someone else's website, can we motion to open a complaint for unlicensed activity against them since they're being listed as a promoter elsewhere? I'd make that motion then.
I'll second that motion.
Thank you. We have a request to open an administrative complaint against the promoter that is under suspension for appearing to be licensed. And we have a motion by Matt Reddish and a second by Christy Halberg. We'll get that open. You'll probably see that in the next meeting, but it'll go out for response.
Thank you.
Thank you.
Motion to adjourn.
Have a motion. It is 3:07 to adjourn. Do we have a second?
I'll second it.
Thank you, Chris. Motion and a second. All those in favor of concluding our meeting, say aye.
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 Thank you. Any opposed?
Aye.
Other things? Thank you very much. Our meeting is over. Really appreciate everybody's time. Thank you.
Thank you.